Justice Bhagavati he has given some kind of explanation for the state, what another state should be. In that thing, we can understand that NCERT is a state. It is a council established by the Ministry of Higher Education. So it comes under state. Okay. These are the important case laws when you come for the Article 12 of Constitution of India. You better you come to the chronological. If you have time, you just see the year of the case laws and note it down in the bracket, so that when they ask for the chronological order, they may, because many questions they are asking in a chronological order, mention the case laws, which year. They will give mixed and they will give options like this case, this year. You know the year, they won't mention the year, they will just mention the case laws. Then you have to arrange it in the chronological order. Yes, yes, ma'am. Garima, yes. Yes. Now that is over for Article 12. Article 13, note on very important. One question you will be getting every year regarding year after, or mostly you will be getting this part. One question will be asked. Surely, I'm saying 75% there is a possibility. Why? Because Article 13 states, definition says that whether that law passed enacted in the parliament or legislative assembly is constitutionally valid or not. Okay. To check these laws whether it is valid or not, we have four kind of doctrines. First one is principle of judicial review. Note down, principle of judicial review, or you can also use a doctrine of judicial review. First one. Second one is doctrine of eclipse. Doctrine of eclipse. Second one. Third one, doctrine of severability. Severability means separate. We are separating that important or which section is something unconstitutional alone. We are separating, not the entire act. That's why we are separating. They are saying as severability. Doctrine of severability. Fourth one, doctrine of waiver. All of them noted the four doctrines. Or anyone not yet noted? Because I will say the case laws, important case laws in these doctrines, so that they will give these four doctrines, and they will both waive off. Waiver. WAIVER. What they will do is they will give these four doctrines, and they will give four case laws in a mixed manner. They will ask us that they will match the following like that. They will be asking the option. You will be getting one question in this. Four options are there, no? A, B, C, D. They will put four case laws in a mixed manner. They will ask. They will give the four things like A means like this one, like that. They will be giving them things, case laws, and we have to match it. So that question will come. Now for first one, judicial review. This is a foreign case, first one, that is judicial review. Madison versus Marbury. It is a Supreme Court of United States of America case law. This may be asked. You note down for first one. Then State of Madras versus V.G. Rao. I am saying for first one alone. Garima, I have given four doctrines for you, isn't it? Regarding Article 13, there are four doctrines there that are judicial review. First one is judicial review. Second one is first case you are asking. Madison versus Marbury. Madison, Madison versus Marbury. Marbury. This case alone is a foreign case, not our country's, United States of America case, so that when they are giving this option in the match of following, you can easily identify that one. Only in this judicial review are having this case law. Okay. Then after this case law, there is state of Madras versus VG Rao. Second case law. VG Rao, ROW, not RAV or RAO. ROW, VG Rao. Second case law. Third one is Keshavananda Bharati case. Keshavananda Bharati case. Fourth one is Minerva Mills case. Minerva Mills versus Union of India. The last one is L. Chandrakumar versus Union of India. So these are the important leading case laws where they can match with this judicial review. Understand? Now we will go for second one. Eclipse. Eclipse, you have three case laws. Deep Chand versus State of UP. Doctrine of Eclipse. Deep Chand versus State of UP. Please, you all kindly note this case laws. If I am having time, I will explain the doctrines also. It will be useful for your name as well as Viva point of view. Are you all noting it? Okay. Doctrine of Eclipse. I am again repeating. First case law is Deep Chand versus State of UP. Second case law is State of Gujarat versus Ambika Mills. And the final one is Dullare Loth versus 3rd Additional District Judge Kanpur. Dulare. Dullare Loth, LODH. Dullare Loth versus 3rd Additional District Judge Kanpur. These are the important case laws where they can ask from the doctrine of Eclipse. Now coming to doctrine of severability. A.K. Gopalan versus State of Madras. A.K. Gopalan versus State of Madras. Doctrine of severability. Second one is the State of Bombay versus Balsara. State of Bombay versus Balsara. Then RMDC versus Union of India. Final one is Doctrine of Waiver. Uttayo versus Income Tax Commissioner. First case law. Uttaya versus Income Tax Commissioner. RMDC versus Union of India, Madam Pooja, Madam. RMDC versus Union of India for severability. Now the doctrine of waiver. See, yes, Deepika, yes. Doctrine of waiver, you know, fees waiver. Waiver means we are waiving off. If there is a, for example, mostly we get income tax cases only regarding this waiver case doctrines. What they do is while calculating the income tax, they may not see. There is a concept called double jeopardy. So you may be taxed twice. For example, your tax has been, your salary TDS is been deducted and by the company itself. Again, then you are getting the remaining amount as a salary. From there, you get again deducted in the income tax. If there is any error inside while calculating the income tax by the income tax department, and you have been levied with the tax assessment, the charge is higher, you may go to the court, and they there are tribunal, but even though you can go to the court, there is this special doctrine called doctrine of waiver, where the remedies you can get. The state cannot, the government cannot just put double times the tax and collect. Okay. For example, scenario I'm saying. So two case laws: Uttaya versus Income Tax Commissioner, Basahar North versus Income Tax Commissioner. Both the case are against Income Tax Commissioner only because of this assessment. Are you all following? That's all. This important part is over. Hereafter, you will be seeing only minute leading case laws. Second case of Basahar, Basheher, Nath, Nath versus Income Tax Commissioner. Okay. Now Article 13 is over. We saw four type of doctrines, important doctrines. And if in the future, if there is any time, I will explain. I will have a special class regarding the doctrine alone, so that it will be useful for you, because in mains they will be asking the explanation of doctrine with case laws. Okay. Other than that, it will be useful for your theory examinations conducted in the law colleges and law schools. Okay. But in exam point of view, these four doctrines are important regarding the fundamental rights, regarding Article 13, so that no. This PDF I am not getting from any sources. I am noting in my own handwriting. So that if you want, I have to scan and again I have to send to you. That's why I am saying you to note it down. Understand? These are the notes which I am preparing. Myself I am preparing, so that there is no any PDF with me from sources. Okay. That's why I'm asking you to note it down. Otherwise, I would have shared to you the PDF easily. When you are writing only, you may come to practice where these are the important case laws. It's a live uh, method, no? Like a talk and chat method only. Okay. No PDF. Okay. If possible, I can make notes and I will scan and send to Vandana, so that you can take it. Will be more easy for you, no? Don't worry, hereafter you won't be getting more case laws. Only this part is we are having four doctrines, and there is possibility, and they are asked questions to match the case laws. So that only I have given this output to you. Okay. Now we are coming for Article 14, equality before law. There we have um, leading case laws like Maneka Gandhi versus Union of India. Important case law. Maneka Gandhi versus Union of India. Are you all noting? Vicky sir. Keshavananda Bharati case versus State of Kerala. Air India versus Nagesh Mirza case. They will say as air hostess case in our law colleges, you know, like she was suspended for being carrying a baby. there is a rules in Air India that if that air hostess, those who are working now, if they are carrying their air hostess, if they are carrying a baby, so that that there is something. Nagesh Misra. So they used that boys, the men alone are not having that kind of things, you know. They are working there like that. They made a case. Then the fundamental right, according to Article 14, all are equal in the eyes of law. So that I am in Tamil Nadu. In Tamil Nadu, women are traveling in bus free of cost. Free of cost, so that I cannot claim that why Tamil Nadu government is giving free of cost travel to the ladies, but not to gents like us. No, there are special provision in the directive principles of state policy. Yesterday, itself I said you don't confuse with directive principles of state policy and this fundamental rights. Special provisions for women is there. Women, SC, ST caste reservation policies are there. In Delhi too. Okay, I'm sorry. I know only about Tamil Nadu. Something I know about the central government. So, like that, people ask fishy questions to me like this during my class. Sir, you are reading Article 14. All are equal in the eyes of law. But women are given free ticket. Ladies special train is coming in the rail trains when I am traveling to High Court campus. What is this there? Like this and all frivolous questions are asked. Special status are there because they were downtrodden before independence. No, now only we are empowerment. Still now the last 106th amendment also is for women. Only one third of the reservation for MP elections as well as legislative assembly elections we are given for women. And maybe if possible, if the population is counted with that respective population, we can give the seats. That also is in the way, on the way. So Air India versus Nagesh Misra and NALSA versus Union of India. Very important case. Transgender are also citizen in the purview of our India. They are given equal status so that every jobs, everything, there should not be any discrimination. If show there is any discrimination, even the parent is discriminating according to Transgender Act 2019. Even if a own parent of the transgender is discriminating the own child, they will be sent to jail. That is important judgment given by Supreme Court of India, as well as we have the Transgender Person Act. Why I am saying specific is out of 100 percentage of transgender born, only 97 percentage, only 3 percentage of transgender are taken care by the own parents. Remaining 97 percentage have been thrown out by the own family members. You all hearing, no? All 38 members here in this meeting, I'm saying it's the statistics. Transgender, we are all human being. When a baby is born, the doctor is identifying whether the baby is a boy or a girl. That is okay. Then in a certain age, we cannot specify the age. In the age of 5 or 13 or 15, even 27, there is some changes in their behavior. The boy or a male person doesn't want to be a male. They want to be a female. Similarly, a female person born don't want to be a female. They want to be a male. This is transgender. That's not their mistake. God's creature. We cannot do that. That's why we have bought this Transgender Persons Act. And I have done a specific research in this concept, and I got an award from the Member of Parliament, Trichy Siva, for researching the topic transgender, social exclusion of transgender in India. One paper I have presented in University of Madras when I was a student there, so that I have some knowledge, research knowledge in the case NALSA versus Union of India, as well as Transgender Person Act 2019. That's why I'm sharing my experience with you. Okay. That's all for equality. Noted. Article 19. Article 19. I am skipping to Article 19 because there is no case laws, important case laws in other subjects. They are case laws are there, but they are not asking in the exam point of view in judiciary. So I am skipping directly to Article 19, right to freedom. There you have Ramesh Thapar versus State of Madras. Note it. Ramesh Thapar versus State of Madras. I am seeing Vicky sir. He is writing. If he says okay, then it is okay. Okay, sir. Noted, sir. Ramesh Thapar versus State of Madras. You noted. Okay. Indian Express newspaper versus Union of India. Yes, yes. Indian Express versus Union of India. Prabhu Dutt versus Union of India. Prabhu Dutt versus Union of India. Then I am skipping to, are you noted? Article 19, important case laws. Then I am skipping to Article 27, very important. MC Mehta versus State of Tamil Nadu. MC Mehta versus State of Tamil Nadu. Now we are on the right time. Another couple of weeks or next month we are going to have Deepavali. Yes or no? Someone reply ma. Yes or no? Ah yes.
Yes.
You know, 20 years back, I'm saying 2 decades years of back. I'm saying 24 years back. Uh, we used to see that in Sivakasi, place called Sivakasi in Tamil Nadu. Sivakasi, there is a place called Sivakasi in Tamil Nadu. There, only we used to manufacture fireworks for overall world. It's a famous place for fireworks and crackers. Yes or no? Now too, you will get you buy crackers. You see the place where it is manufactured. You can notice no Sivakasi. Yes or no? Can anyone say yes or no? Ah yes. So there, 20 years back and all, when we used to see that child labors were there while for manufacturing this fireworks as well as matchbox. So MC Mehta is a lawyer. He has taken many tremendous pro bono service in pollution cases, gas tragedy cases. He is a very known lawyer. So he has taken this case in Tamil Nadu and got justice in this matter. And the article we have got Article 24 that compulsory no child should be employed till the age of 14. So important. It's a fundamental right. That's why in the state of Tamil Nadu, when Kamaraj was the chief minister of Tamil Nadu, I'm saying in 1960s, when he was the chief minister of Tamil Nadu, he gave free food for those who are coming and studying in government schools, so that for food they will come. Now today, the chief minister of Tamil Nadu has only done one good thing in this tenure by offering free food for tiffin, morning tiffin. That is the only good thing he has done after his being elected as the chief minister of Tamil Nadu. So food is important. They are providing food. This all comes under it's a fundamental right, but it is also connected with the directive principles of state policy. Fundamental right. So any person as a lawyer, when we see anyone outside, if I saw for example, my family, they won't come with me outside because if I see any illegal things happening, like if I'm going for workshop or bike workshop, any small child is working also, I will shout at them so that they won't come with me. Anything transgender people and all, if they come and all, I will grab their hands and I will become friend with them. So that my family itself, they won't. They are avoiding me. They won't come with me very often because I am a constitutional lawyer, no. So that I am. uh, I will take steps against when there is any fundamental right violation. If I saw through my eyes. Okay, understand. So it is very important. Thank you. And that's all for fundamental rights. And thank you, Sanjay. Thank you. Thank you. Thank you. Now you are all free with uh, to note the case laws. No more case laws. We can see case laws afterwards or tomorrow. Okay. I didn't say about a case laws in Article 27. I said about Article 24. 24. Article 24. Okay. Case laws, every article we have important case laws, but it is not possible for me as well as you to grasp everything. No, we need more classes. We need a exclusive one, at least one period like class. Say for Constitution of India, I am learning Constitution from my law degree. I have read Constitution 1 and Constitution 2. Then after that, in ML, Master of Law in Constitution Law and Legal Order, there too we are incomplete. Last year I was given a task of teaching Constitution for engineering students. Yesterday I said to you, only Constitution that is till 51A. History of Constitution till the fourth part, fourth A part. We have till fundamental duties I have to take. But even though we cannot complete the amendments, many things are there. So that very important case laws only we can deliver. Other things we have to um, get through our own knowledge because different type of people are there in this meeting. Some are well versed advocates, there are practicing lawyers are there in this meeting. Students, maybe some students are doing ML. Those who are completed ML are also practicing. They are there. Some are studying law program, BLLB or 5 years integrated course as well as 3 year LLB. Then some joined the law program and still not yet added the Constitution of India class. So different type of people are there in this meeting, so that the matter which I'm delivering should be some value to them. That's why I'm precising the topic to the level for exam point of view. And please, you noted today all the persons, those who are there now in this meeting. See, judiciary is a very, very toughest task, not only in executing the judiciary for preparation also, because we are preparing for judiciary prelims are there, then mains are there. There mains we have 4 papers that we have to clear, and after that we have to clear the viva, that is main interview. These things are there. Here, the main thing is not reservation or the tickets available. Because why I'm saying this is last civil judge examination, there are 350, almost 349 vacancies in state of Tamil Nadu in the year 2018. But they recruited only 250 people. 100 people they cannot find. 100 people they cannot find means what? They are not eligible. They, many of them failed in the judiciary exam. Last simultaneously we had opening for 4 district judges examination for 4 district judges. Almost 5,000 people appeared for the district judge examination, and not even one was selected for the district judge. I don't know what kind of thing they are using, what kind of mind they are applying. So judiciary process, selection process depends about state wise. You know, in Kerala, in state of Kerala, those who are listening here, I'm saying, in state of Kerala, those who are assistant professor of law in government law colleges in Kerala can be appointed as a judge, civil judge, as a in-house transfer. In Kerala, they are doing. Other states are doing this activity. No, it depends upon the state. So, actually yesterday I gave you an homework to read Article 124 plus 3C of Constitution of India. Did anyone read? Anyone read yesterday's work where I gave you to read the Article 124 selection or appointment of judges of the Supreme Court? Anyone studied? Not, no one is replying. Ah, Deepika, right. See, distinguished jurist means a professor, eminent lawyer, a professor, eminent jurist in an academic field is a person. But till now, not even one person is being appointed in this judiciary. Yesterday, one sir, Prabhakar is name, I think so. He's asking the line between judicial activism and judicial outreach. Judiciary itself is totally it's incomplete. No, then why we are talking about judicial outreach? So that it is incomplete. Why I'm saying this is in Germany, Supreme Court of Germany has 18 Supreme Court judges. Out of 18 Supreme Court judges, 9 persons are law college professors. But you have any, your people are here. Why I'm saying this is maybe now there is no space because I'm working it. My research is on that only. I'm working on it, and if possible in the future, you all have the opportunity to get a ticket, even when you are a assistant professor and associate professor. You're going to be a professor. That's why yesterday also I said this ticket. Remember, not only me, my colleagues will be teaching you. You remember this, not only you take this classes for granted only for judiciary, make it as a wonderful opportunity for you to crack your higher education examination like CLAT or whatever individual universities they are conducting for their Master of Law, ML or LLM examinations. And also those who are completed your ML, those who are there, those who are completed your ML, you can appear for UGC NET. That is useful there. This is the same question they are asking for NET also. So judiciary, if you are well versed and getting a judiciary, you can also get through UGC NET. You are qualified as an assistant professor. You can join any university as an assistant professor. This experience will be counted. Meanwhile, but this cannot be counted as an experience as an advocate. That is a problem, minus point in that. So in future, there is a thing in constitution it is saying, but still not it is done. That's what we are saying. Maybe in the future you will be getting an opportunity. Those who are cracking your UGC net and being assistant professor or going to be an academic lawyer, you will be getting an opportunity to directly get appointed as a judge in the future. Maybe now there is no opportunity. Yes, Deepika. I am researching in that topic. Okay, nothing. Distinguished jurist means whose experience in law after advocates and judges. That's what yesterday I said. I'm saying it's a top secret. I'm doing research in my PhD, but I revived today. Okay, we are doing some research because Constitution says that a distinguished jurist may be appointed. Regarding that, I am giving my thing, my opinion that judiciary also you are going means you go, you have the second ticket as well as for your higher education. Okay, this competitive world, many people are, many law colleges are there, many lawyers are there. So in order to sign, we should have not stick only with our LLB or 5 years integrated course. So you have to be a master. Complete. So I advise you all to complete your master's program like me, and you can become an assistant professor. You can pursue. You are a PhD. You can have a doctor before you are named like our Chief Justice, Dr. Chandrachud. Okay. What Vicky, Dr. Vicky? Dr. Deepika, okay, like that, that thing you will be getting. So this is a single motivational single ticket for you. That's what I'm up to say to you. Now, regarding the thing, Article 32, Constitution of India, Article 32 and 226, we have discussed about the writs, no. So there is a possibility to point out four types of writs and they will ask to match the thing for which, for example, ABS corpus. ABS corpus means illegal detention. When there is illegal detention, you want a person to appear, that the court will order the police to bring that person to the court, body, either by body or thing. That is habeas corpus. Like that quo warranto, illegal, yes, illegal detention. Like that quo warranto, which in what position that fellow is there? Yeah, there is a minister in Tamil Nadu. He's a son of chief minister of Tamil Nadu. That fellow is talking. He's giving his kind of thing words in a public meeting about Sanatana Dharma. You come across that word, no? He's a minister. He's in a constitutional position. He's saying some kind of wordings regarding Sanatana Dharma, and now in the court, he's saying that no, I didn't say in the position of minister. I am just saying in the man of yes, Udayanidhi Stalin. I don't want to say his name. That's why I'm saying. So this person from Vishwa Hindu Parishad or Hindu Munnani, there is a party that was made a case, writ petition filed in which in written of warrant, in which position he is there, this fellow. Huh? He is being minister, sports minister, and in which position he is talking. Now he is giving explanation in the court. No, I didn't say it in the point of being a minister. Backing. Okay. Now when you're coming to the court, you are backing off. You have to stand with the word, no, whoever it may be. So that kind of thing I'm saying. So these kind of writ petitions that habeas corpus, certiorari, prohibition. Prohibition means it is giving the order to the lower courts. It is connected with the lower courts to stay on the order. That thing we will take care of the certain cases pending. They are giving a command to the court. Command they are giving to the court or tribunal. That is prohibition. They are commanding the government officials or government authority, except the president and governor. They are giving the commanding the authority to do the activity. They are commanding or making an order to do that means it is what the writ. Mandamus, writ of mandamus. So that these kind of things you have to. Five writs are there. They will ask any four and they will ask two match. Okay, understand? Everybody understood? Okay. So that's all. Something I was feeling lacking and incomplete with the case class in yesterday's class. So today I have fulfilled the my students with the delivering case class. Now we can see the second chapter, union and the state executive. Shall we start? Okay. For union executive, the position, the utmost executive, who's the executive head of our country? Article 52, the president. Yes or no? Yes, okay. So they will be asking the regarding these questions like eligibility of the year, the age. See, according to Article 58, he must be a citizen of India. He must have been completed 35 years. He must be qualified. He must be qualified for the election of member of House of the People. He must be a person to be qualified. It means what to be then he cannot be a member. For example, Pranab Mukherjee. Pranab Mukherjee, former president of India, while being selected as the president of India, he was a member of Lok Sabha or Rajya Sabha, I think so. He was a minister, I think so. He was a finance minister, I think so. Then he resigned his finance minister position and he contested for the election for president of India on the advice of Sonia Gandhi ji and our Manmohan Singh, Prime Minister of India, and he was elected as the President of India. As soon as he elected, he resigned his position of member of parliament. So he cannot be a member of parliament. As soon as a common person, anyone 35 age, he can be a president of India. Abdul Kalam, scientist, has been a president of India. You can understand, no? So when he become a president of India, he cannot be a member. But he is the head of all MPs, and I mean, he can be the president together with Lok Sabha and Rajya Sabha is the parliament. So he has to accent. Final accent is given by the president. He has some enormous powers that I will say. Article 361 is very important. Article 361. Note it. Because they will give some articles and say which article guarantees the privileges for the president of India. So he cannot be called for any inquiry or anything in the court of law, even in the civil proceedings when he is in the position of the or in the term of the office. So Article 361, privileges of the president of India. Article 361, I repeat, Article 361, 361, 361. Because they will give four articles and choose which article gives the privileges of the president of India, like that they will ask privilege of the president. Okay. Then powers of the president of India. Yes, executive powers. Executive powers is the commander in chief that you know. Then he is a person appointing the judges of Supreme Court and High Court. Judges of Supreme Court and High Courts are appointed by the president because see, this is a method like we have collegium. Supreme Court, there is a thing called collegium. This subject which I am talking is under judiciary. Since judiciary is independent, we have independence in judiciary. The collegium consists of chief justice and senior most judges. And the state, for example, Madras High Court, anyone has to be elevated from the lower level judges, like district judges will be appointed as High Court judges, and some senior most advocates, those who are practicing notice, those who are famous in practicing original side practice, as well as with petitions and all. When your face is very familiar in the court of law, both in Supreme Court as well as High Court, I already said yesterday. Yes, yes, yes. I am talking up where we are talking about only constitution, so that I don't want to touch that subject. Okay, understand? Yes, yes, yes. So now back to the selection of judges. This collegium will select, and this thing, the selection list of the collegium will go to Ministry of Law, Central Government, Government of India. It will go. Then that list will from the ministers, that cabinet ministers department, it will go directly to the president. Then president will give orders, name by one name, powers conferred to her, so that she will give a who he or she will give the warrant. Warrant means it's like arrest. So 1 month before you will go, who and all judges, I'm saying High Court judges, those who are advocates, those who are selected as judges, they will come under the ambit of CBI. So the calls will be recorded, no privacy is there. 1 month before, sir, the list will go to CBI. Somewhat it should not be no as per law. Tomorrow there is a person selection list is coming means tomorrow only they will know. But nowadays 1 month before itself they are knowing they will be selected as High Court judges and Supreme Court judges. See, there is no secrecy maintained in the act of selection that I want to say. So that's what I said here. So they are being selected as per powers conferred by the President of India. Governors of state, governors of state are appointed by the President of India on the advice of the Council of Ministers, including the Prime Minister. Now, for example, in the future, our ILA is going to be a party, and we are going to be. I am the Prime Minister. Our DD Gupta ji is the Prime Minister. Okay. Now, Deepika ma'am, she is asking. She is very active. Deepika ma'am is very active, so that she belongs to somewhat like Madhya Pradesh. In Tamil Nadu, there is a vacancy for governor position. I can recommend. We can recommend to the president. President, our friend is someone you will appoint as the president. He will be the president. So that due to our recommendation, Deepika madam will be governor of that state, and till till she can hold the office five. There is a till the 5 years. Then in between, if she wants to resign, if she can resign. So that's the rule. So from the date of appointment, and if even next party is coming some till the or the pleasure of president work. If there is, that's what. If there is any problem, there is any discrepancy in the service offered by the governor, any problem, any misbehavior, anything means they can. That's correct. Deepika, you are correct. So that won't come in the questions. So that to give a detailed input, I'm saying. For example, sorry for just the example I said. Okay. Then Attorney General, Attorney General, Attorney General and Controller and Auditor General are appointed by the President of. Okay, Madam. Okay, President of that we will see. Governor you will see in the executive, state executive will see. Still, I am in the Union Executive. AG, Attorney General. Attorney General is a very powerful person because he is the only person who's not a member of parliament. Anytime he can enter the parliament and answer before the speaker. Do you? Everyone knows, no? He's having that power. That thing you have to know as a lawyer. He's yes, people are saying yes. He is an authority now. He's also a master in constitutional. I think so. So AG has that power. That for general knowledge purpose as well as they may ask this no, they may ask this question in the Viva, that is interview, face-to-face interview. They will ask this question: who's the person apart from member of parliament who can straight away enter the parliament and appear before the speaker? They will ask this question because he is the AG, he is Attorney General of the country. Any other problem, any other issues, legal matters, any other law questions, the he may answer before the speaker and the member of parliament in the parliament, both houses. Okay. Apart from executive powers, military powers, president is the supreme commander of defense forces. But 2 years back, we have bought a new position. What position? Can anyone answer? Equivalent to the supreme commander. That position. Ah, CD. Correct, correct. Bipin Rawat died in Tamil Nadu in a helicopter accident. So in our defense, we have yes, yes, okay. We have three kind of defense mechanism. One is army, that is military forces, army. Then air force. Then navy. Army used to salute like this, showing that they are few-handed, and navy we used to salute like this. That is their position, and that is air force. Air force will salute like this, and navy will be salute like this because they are working in ships. No, there are some work like while sailing. They are working so that even though their dresses are white, their hands will be getting dirt, so that these kind of things are there. When a president is arriving in our any state like Tamil Nadu, you notice all these three heads of the defense personnel will come. You notice the salute given by them. Army will be saluting like this, and Navy will be saluting like this. Air Force will be saluting like this. Difference as a word of knowledge and giving you to all. This position, newly introduced position, is equivalent to the president, because while creating this position, opposite party said that it is equivalent to the president of India. There may be chance of getting the emergency like that, and I know they will be more powerful. So that Rahul Gandhi ji said that it is not fair to give like this position. Already three forces are there. Why you need another? We have president as such a commander, chief supreme commander. Why you having another chief subordinate to you? So that these kinds of questions they were asked. Now it is a important thing to me. Okay, diplomatic powers. We have foreign embassies in our country, as well as our country's embassies in several countries. We have sir, nice sir, Aditya sir. Uh, Diplomatic powers are there for president to send our foreign service officers. Today we have the external affairs minister. He was the prime before being appointed as the minister. He was a principal secretary for external affairs, and he has been a ambassador for representing our India to many countries. So he is in the right position now. Like that, president is having power. Every position, whatever he do, he does it. He or she does it in the advice of the prime minister and the council, cabinet. Legislative powers. Legislative powers. What to say? If there is any commencement of emergency or any other fall of the government in ordinance making power is Article 123. I will come next. Okay, this is legislative power. Okay, because he's having the power of appointing 12 members for the Rajya Sabha in the opinion of the Prime Minister. Okay, so that I'm saying that legislative power, because how many members may be appointed by the president in the upper house? They will give option A 4, option B 10, option 12. I already said. I'm saying option C 15, option C 20. Like that they will give. You have to choose 12. For that I'm saying. Understand? Ordinance making power, special ordinance. I came across a case now in your New Delhi. There is an elected government, Chief Minister. Yes, sir. Won't degree. Who's the Chief Minister in Delhi? His name? Ordinance making power. Who's the Chief Minister of Delhi? Kejriwal, Arvind Kejriwal. So there was a clash between the Chief Minister and the Deputy Governor in Delhi. So what Supreme Court said that the Chief Minister is being selected by the election of the people. Uh, he is a elected. That is an elected government. So governor is bound to act on the advice of the Chief Minister. Yes or no? Yes or no? The judgment given, no? Yes or no? Yes. But what happened after the judgment? 1 week after the judgment, there was an ordinance passed in New Delhi. Am I right? Am I correct? No, 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 no. I am the president of country. President is giving the order. Ordinance passed. I am the president of the country. You cannot consider Delhi equivalent to state of Tamil Nadu or Kerala. Yeah, this is Delhi. This is the entire government. Union is been functioning in Delhi. I am having special provision that the Ordinance Act, if you see, means even the prior judgment, even the judges opinion or order saying that deputy governor is bounded to the orders of chief minister was being set aside by the executive. Now the answer is being given to yesterday's question. Judicial activism, there is a line between judicial activism and judicial overreach. Here there is no overreach. As per constitution, only justice has been delivered. But what the ordinance power is passed? No, she's having the power. President we have many departments, entire countries, ministry, every diplomats, everybody are in the capital of India. Delhi is a capital of India, so we cannot consider Delhi with the other consider Delhi with other union territories or other state of the country. Okay, that's why this ordinance has been passed. I am giving an example. Questions may be asked with that new ordinance. Okay. Article 72, pardoning power. Very important. Article 72, pardoning power. Important case law, K.R. Singh versus Union of India. K.R. Singh versus Union of India. This is Indira Gandhi assassination case. Everybody hearing? Only 27 members are there. Others went.
Sir, can you repeat again case name?
K.R. Singh, K.E.H.A.R.
Okay, sir.
K.R. Singh versus Union of India. Indira
Okay,
Gandhi
sir.
assassination case. I don't want to go inside that Indira Gandhi case. It will take another half an hour. So in this case, why is a landmark judgment? Yes. Deepika, correct. Landmark judgment. This fellow, through his representative, has applied for pardoning his death penalty to the President of India. President, on the advice of the um, government, Prime Minister and cabinet ministers, they rejected the pardoning. Again, he is going to Supreme Court. That the President has rejected my appeal for pardoning. No? That is open. What judiciary said, Supreme Court said is that is purely President's discretion. We are neither bound to advise or order or interfere in that matter. Pardoning power is totally is under the control of President, and it is not fair also, no. See, judgment is operating time by time and depending upon person and person. See, this class is not only for judiciary preparation, while inside I'll give some landmark views for you. Why I'm saying this, you know that Rajiv Gandhi assassination case in Tamil Nadu. Everybody, now we talked about the President of India pardoning power. There is a case called Rajiv Gandhi assassination case. Last 6 months back, one person was released by the Supreme Court. You know that? Justice Nageshwara Rao, Supreme Court judge, before he is resigning, before he is retiring, he gave a judgment, the pardoning power, regarding the pardoning power of the governor. There, what is he has said, no, governor should have given the pardoning, or you have to say yes or no. You should not keep the file as said, either yes or no. In 20 years back, but almost this fellow has spent 24, somewhat, how many years? My age is 31. He is 32, 33 years in jail itself, this fellow. So it is like a double jeopardy. Either you have to give death punishment. Okay. So 32 years he is in the jail. So that he was being released by the Supreme Court. It's a landmark judgment in union. I am saying about state executive. Now, what we are talking about is president's pardoning power. This comes under pardoning power of governor. Our governor R.N. Ravi is the governor of Tamil Nadu. Now, important about the president is over. Now, I'm going to vice president. Powers vested upon Article 63, vice president. Apart from president, the vice president is ex officio chairman of Rajya Sabha. And in absence of prime minister and in the absence of president, um, due to his death or any other problem, so he be act as the president of our country. That thing is there for him, and he may act as a president, as whatever powers vested, even appointment, everything he can do in the absence of the president. Okay, that is the thing. And it is in Article 63 and Article 74, Class 1, Article 75, Class 1. Powers vested for the vice president. So that's all about the vice president. Now I am coming to state executive. State executive, the governor. The executive head is a constitutional head to act according to the advice of the Council of Ministers. Article 153 creates the office of the governor. The governor of the state is appointed by the President of India under power vested upon him under Article 155. So 153, governor, appointment of governor, Article 155. So eligibility criteria, Article 157. And the tenure and removal of the governor, as our Deepika madam said, Article 156 of Constitution says governor shall hold the office during the pleasure of the president. The office of the governor is fixed for 5 years from the date on which he or she enters upon his office. He may be removed from his office at any time by the president. Governor may resign his office by writing to the president. So that's it. If there is no problem at all, they can be till the 5 years. Even next government comes also, if they think that this governor is not acting now, they can remove. That is the thing. Same powers we have executive powers vested upon the governor. Governor appoints the chief minister after the election. He will call the person who is having majority, and he will call the person. There are he shall invite the leader of alliance or coalition front of which formed before the election and return with the majority. He should invite the leader of the single largest party. He should invite the leader of the front formed after the election. So that's the appointment of chief minister and the cabinet minister. Pardoning power under Article 161 vested upon governor by Constitution of India. K.M. Nanavati. K.M. Nanavati versus State of Bombay. Landmark judgment. K.M. Nanavati versus State of Bombay. Here in this case, nothing but when the case is in the judiciary, when it is in the sub judice, that pardoning power is not activated or cannot be activated. Then the judgment, see that in that case, the High Court confirms the death sentence for the person. Then when she goes for the appeal to the apex court, at the same time she is giving the pardoning petition to the governor for this. That they are mentioning this issue in the apex court. Judges say that when the case is sub judice, when the case is before any court of law, you cannot go for pardoning power. If after the final judgment, they can go. Understand? Any other doubts? Usually, many people out of Constitution of India during the face-to-face interview or whatever is this kind of what, sir? Vicky, sir, you have doubt? Oh no, no, Okay. See, I am giving you an input for you. This is a very important question is being asked in the judiciary Viva voice. What is why they are putting LLB in our degree? Why they are putting LLB? Can anyone answer LLB? Our LLB. Why they are putting LLB in our degree? Just unmute yourself and answer LLB. Because many of them are not answering this question in the judiciary Viva voice. It is a Latin term, legum baccalaureus. That we know. But why LL? Legum baccalaureus means LB only. No, why LL? Why they are putting LLB? Don't say Latin legum baccalaureus. No, not that. See, listen carefully. These 27 members, those who are attending this video call, we, while mentioning the correct, Parul Shukla, correct. It's a plural form. As Parul Shukla saying, it's a plural form. Judges, when a single judge is sitting, we put the judge name and put a J. For example, Justice Kirubakaran, Honorable Justice Kirubakaran J. When there are two or more judges are sitting somewhat in constitutional benches, 5 judges bench, like that people are sitting, no, that time we will put no the Chief Justice name and the remaining 4 judges name. The finally we will mention as JJ. Understand? JJ means judges. JJ means judges. Similarly, you are not Bachelor of Law. You are Bachelor of Laws. You are not only studying one law, you are studying many laws. Constitutional law, you are studying contracts, you are studying property law, you are studying nowadays maritime law also introduced in honest courses, taxation law, like that many number of laws you are studying. So you are a Bachelor of Laws. So laws is a plural form, that's why they are mentioning LL. This answer no one is answering in the Viva or face-to-face interview. So it is connected to the constitution because constitutional lawyers, judges sitting, we used to mention JJ, same matter, yeah, laws. So we are studying Bachelor of Laws. That's why to avoid confusion in Tamil Nadu alone, we used to say BL, not LLB, BL, ML, not LLM. Now, as per UGC norms, everybody compulsory we have to mention hereafter degrees should be. Thank you, Alima. Thank you. So this answer you have to know. Okay, some people ask why bar. These are the questions asked. Local people, common layman, asking what is this bar? Why you are putting bar? Understand? You have to be in the position to answer. Why? Because the experts say that we used to say as bar at law, barrister at law. Before advocates, we used to enroll in our country was under the rule of Great Britain. So that while we are enrolling, we will be enrolled as barrister at law in bar association, which is a preview council, which is in England. So that we used to be adjudicated affiliated to that bar council so that the advocates were used to be called as bar at law, barrister at law. After Advocates Act coming only, we have Bar Council of India and state wise we are having Bar Council. That barrister is named that they cut shorted to bar. So we have Bar Council. We are enrolling there. Then now we are, that's why it is called bar. Another explanation given by my senior is, bar magnets. We have north side and south side bar magnet. Our table will be like horseshoe magnet. You see our bar bench. Bench is the place where judges sitting. Bar is the place where we are sitting. We advocates used to say it's like the form of horseshoe magnet, U shape. Yes or no? One side we used to a petitioner, we used to appear for petitioner. Other side we used to appear for the respondent. So there are north and south side. Maybe the bar magnet size and this U shape R2 magnet position is different, but the characteristic is same. Bar magnet characteristic is same. North side, south side. If both of them are acting in one side, there is some problem in the advocates. So that to govern only there are a bar council and bar association. That's also the reason why they call us bar council. These are the common questions asked, and we have to be in the position to answer. These are the questions they are asking. First question these are asking. The judge is asking what is pill. Pill is not explained by any article in Constitution of India. They will ask simply what is pill. What is the difference between pill and other cases? So you have to be in the position to answer. Pill means public interest litigation cases. Where any cases we appear before the court, there should be some locus standi. Okay. We are appearing on behalf of the petitioner. Okay. That petitioner should have some locus standi in the case. Otherwise, the case will be dismissed. But in public interest litigation, there should not be. There, we don't have the legal, the traditional or customary practice of having a locus standi. The court wants to see the locus standi. Yeah, it's a pro bono public. That issue must be there must be a public issue like pollution, like child labor case brought by MC Mehta, that's the state of Madras, like that. One public issue. National Services Union of India, transgender people are affected in jobs. So discrimination is there. One public issue. When there is a public issue and that fundamental right is being violated, when you are going to the courts of Supreme Court as well as High Court under Article 32 in the Supreme Court and under Article 226 powers vested in High Court, we are going. It will be coming. We will be applying it in the writ petition only. But it is bill. So this kind of question they'll be asking, but it is not mentioned in our constitution. It is a part of judicial activism, and judiciary is allowing. Sometimes frivolous cases are coming. Some people used to ask Supreme Court to declare India hereafter Hindustan. One case is coming. Judges said this is none of our business. You are wasting the court time for you, 2.5 lakhs fine. Like this frivolous cases and all will be coming. It's not public interest case, that is private interest case. The judges know whether it's public interest or private interest. That knowledge as a lawyer we should understand. We should come to know these kind of questions they be asking. So some explanations during the classes, I'm giving some detailed explanation. I'm giving means it is not waste of time. You please grasp it. It may be asked in the face-to-face interview or your mains, because after completing your prelims, you have mains. Mains we are having 4 category. There in state of Tamil Nadu, we are having one paper for translation, one paper for issues framing, one paper for framing of charges, and another paper. What is that? Thing, mains is there, but CPC, CRPC, Constitution of India, they will ask descriptive type questions. All exams you will have 100 marks. In all the 100 marks exam, you have to pass. You have to get 40 marks. Some say 35 marks. All the 4 things you have to complete and you have to get. It is not easiest task, because it is a lifetime settlement for being a judge. Even a god is coming, you have to judge. That is the power of judge. You can judge. Even a god is coming, you may make, as an advocate, you may make the god to stand in the witness box and ask the defendant as well as ask questions. That's the powers vested in the advocate and the judges and the court of law. So that knowledge you should have. Everybody should have. These are the questions asked in the bio-wise constitution. So next, what is it? Boring, or shall I continue, or shall I complete with this today? Shall I continue or complete with this today? Deepika saying continue. What about the other people? Yesterday I asked you all to see Article 124 Class 3Z. Some maybe 1 or 2 are answering. What man, Vicky always saying no, sir, means what? Don't want to continue, what? Vicky? Vicky, sir. Okay, I will continue, no problem. Now we can see union and state legislature. Sir, I don't know Hindi, sir. Vicky, sir, I don't know Hindi, sir. Sorry, sir. If Redford. Okay. Okay, sir. Okay. Union and state legislature. As I already saw, sir, you said you want to go to Red Fort, but now you are appearing before me. Okay, we will. Why, Deepika ma'am, you are crying? Okay. We can continue with the union and state legislature. See? No, sir. People are people like Deepika are waiting for my lecture. So for if you are having any other important okay, today is Dasara. Yesterday we had Ayuda Puja. In spite of that, I am taking here also we are having Jayadashmi here, but I am taking classes. That's why I'm asking if you all want to get to stop here means I'm ready to stop. If Vandana ma'am says means I'm ready. Vandana ma'am, what to do? They are asking. Vandana ma'am,
Yes, sir.
they are asking to stop till now because they are going to Red Fort or for Dasara celebration. What to do?
Yes, sir. We will wrap up.
Okay.
Okay, sir.
The convener has given the accent. Now she is the president of this
Because
session.
today is a festival, so everybody want to go for the
Okay.
festival.
Happy Dasara. Good night. We will meet
Thank you
tomorrow.
so much, sir.
Okay.